everyone. Welcome to Crime in Court. This is the Canton cover up series Commonwealth versus Karen Reed and Turtle Boy, Aiden Turtle Boy Carney. We also talk about him, and that's whose case we're going to be talking about today. In fact, this episode is titled one or this is the 121st episode of the Canton cover up, and it is titled Backfired. Chris Albert Gets Self Owned. And what I mean by that is, so let me give you a little update. The last few weeks in the Karen Reed and the Turtle Boy cases have been just insanely busy, and so much has been going on. So I don't remember the specific day that Turtle Boy went to court, but when he did, they tried to get him on another charge, and this charge happened to be him late at night leaving C.F. McCarthy's after drinking quite a few, and no one, I mean, no one was at D&E Pizza, which is the restaurant that Chris Albert owns. For whatever reason, Turtle Boy stopped and was standing in front of the D&E pizza shop, closed, lights out, nobody there, and started kind of doing a bit where he's got the Glare from the Glare's YouTube channel. There were a bunch of people in town because there was the motion to dismiss for Turtle Boy and Karen Reed to be heard last week, like at the same, couple days apart. So they did that, and they were all in town, and they went out to drink and have a good time and go out for dinner. And they left CF McCarthy's, and whatever happened, I don't they did finally release the audio video. So there's audio and video, basically is what I'm getting to, of Turtle Boy kind of, they say it's intimidating Chris. He's intimidating a window, let's be clear. And if Chris didn't have illegal recording devices, he never would have known about it. And that is the key issue here at hand. So they were able to charge Turtle Boy with standing in front of a pizza shop window with no one around, as he kind of did a bit when he was entertaining multiple people that were standing on the street there with him, and talking about Chris hitting Peter Berger long time ago before he became a selectman of the town of Canton. And he Peter Berger was a foreign exchange student who was in town, whatever, and he was driving around with a female in his car in the passenger seat, and Chris, after presumably some drinking, um, hit and ran. He hit this individual, Peter Berger. Peter Berger lost his life, and the female was injured, and Chris went in hiding. And now he's a selectman for the board of Canton. Basically, he is the boss of the Canton Police Department. So that's kind of a conflict of interest, don't you think? When the Canton Police Department is investigating the homicide of Officer John O'Keefe, who was found outside Brian Albert's lawn, the brother of Chris Albert. So that's kind of where we're at. And I wanted to go through first up what this. So Massachusetts has a wiretapping, interception wiretapping law that is quite strict. It's probably one of the most strict in the country about illegal wiretapping. You cannot record someone without their knowledge and consent. You cannot record audio. You can record video if there is a video, like in public, if you um, had like a street camera, you can see it. It's not hidden. You know it's there. So and it doesn't catch your audio. So that's the big difference with this. And their law is, well, we're going to go through there. It is general laws, Massachusetts section 99, general law section what is it? No, sorry. That's not right. General Law, Chapter 272, Section 99. That's where we're at. And this is interception of wire and oral communications. Please hit that like button as we dive into this. All right, so Section 99, interception of wire and oral communications. The General Court finds that organized crime exists within the Commonwealth and that the increasing activities of organized crime constitute a grave danger to the public welfare and safety. Organized crime, as it exists, this is funny that they're talking about organized crime because there's kind of a McAlbert syndicate going on in Canton. Organized crime as it exists in the Commonwealth today, consists of a continuing conspiracy among highly organized and disciplined groups to engage in supplying illegal goods and services. In supplying those goods and services, organized crime commits unlawful acts and employs brutal and violent tactics. Organized crime is infiltrating legitimate business activities and depriving honest businessmen of the right to make a living. The General Court further finds that because organized crime carries on its activities through layers of insulation and behind a wall of secrecy, government has been unsuccessful in curtailing and eliminating it. Normal investigative procedures are not effective in the investigation of illegal acts committed by organized crime. Therefore, law enforcement officials must be permitted to use modern methods of electronic surveillance under strict judicial supervision when investigating these organized criminal activities. So they outline first things first, law enforcement has the right to to get audio and video of individuals when it comes to a criminal investigation. The General Court further finds that the uncontrolled development and unrestricted use of modern electronic surveillance devices pose grave dangers to the privacy of all citizens of the Commonwealth. Therefore, the secret use of such devices by private individuals must be prohibited. As far as I know, Chris Albert, even though he's on the board of selectmen, he is still a private individual and he should not have surveillance devices, which we know he's been using because he's been trying to get any person on the sidewalk, and now it makes sense that he's had audio this whole time because he's been trying to get anyone on the sidewalk who has like a Free Karen Reed shirt on, or one woman wrote that, well, we'll hear about it in Mark Betterow's letter, but one woman wrote on her car FKR, which stands for Free Karen Reed, and he, started saying derogatory things about her. So how he knew, like he's just watching and like spying on these people and trying to get like witness intimidation charges on anybody that has any kind of allegiance to Free Karen Reed. So that's kind of what's going on with Chris. So, the use of devices by law enforcement officials must be conducted under strict judicial supervision and must be limited to the investigation of organized crime. So, if we're going to audio tape you, it's probably because we got a wire and we have a warrant to do so. And somebody's talking to you or whatever. You know what I'm saying? Like, as an example. But in this case, Chris Albert just has audio of people walking on the street. That's illegal in Massachusetts. Definition as used in this section. The term wire communication means any communication made in whole or in part through the use of facilities for the transmission of communications by the aid of wire, cable, or other like connection between the point of origin and the point of reception. The term oral communication means speech, except such speech as is transmitted over the public airwaves by radio or other similar device. So the things that Turtle Boy says on his show, if he said, Chris Albert, you better change your testimony or I'm going to hurt you, that would be witness intimidation. If he said that on his show, that would be okay. But if he was talking in jest with his friends and saying something along the same lines, but he was being recorded and not, not against his will, he was being recorded, then that is illegal oral communication reception. All right, so the term intercepting device means any device or apparatus which is capable of transmitting, receiving, amplifying, or recording a wire or oral communication other than a hearing aid or similar device which is being used to correct subnormal hearing to normal and other than any telephone or telegraph instrument, equipment, facility, or a component thereof furnished to a subscriber to or user by a communication common carrier in the ordinary course of its business under its tariff and being used by the subscriber or user in the ordinary course of its business. So, like a phone, or being used by a communications common carrier in the ordinary course of business. So, like intercepting someone's communications on their phones. The term interception means to secretly hear, secretly record, or aid another to secretly hear or secretly record the contents of any wire or oral communication through the use of any intercepting device by any person other than a person given prior authority by all parties to such communication, provided that it shall not constitute an interception for an investigative or law enforcement officer as defined in this section to record or transmit a wire or oral communication if the officer is a party to such communication or has been given prior authorization to record or transmit the communication. So there's exceptions, but this is not going to fall under that exception, even if they're saying that it's intercepted for an investigative and law enforcement officer. Well, that's not true because the person who has access to this is Chris, or Chris was able to get their law enforcement, the Canton Police Department, to intercept like camera audio. So maybe the town of Canton has audio that's being recorded, or it's Chris's audio being recorded. Either one, somebody's committing a felony here. All right. So the term contents, when used with respect to any wire or oral communication, means any information concerning the identity of the parties to such communication or the existence, contents, substance, purport, or meaning of that communication. The term aggrieved person means any person who was a party to an intercepted wire or oral communication or who was named in the warrant authorizing the interception and who would otherwise have standing to complain that his personal or property interest or privacy was invaded in the course of that interception. So Turtle Boy's privacy was invaded during that interception of this most recent witness intimidation charge that like I can't even say with a straight face that they're intimidated by him. The term designated offense shall include the following offenses in connection with organized crime as defined in the preamble: arson, assault and battery with a dangerous weapon, extortion, bribery, burglary, embezzlement, forgery, gaming in violation of Section 17 of Chapter 271 of General Rules, intimidation of a witness or juror, kidnapping, larceny, lending of money or things of value in violation of the general laws, mayhem, murder, or any offense involving the possession or sale of a narcotic or harmful drug, perjury, prostitution, robbery, subornation of perjury, any violation of this section being an accessory to any of the foregoing offenses, and conspiracy or attempt or solicitation to commit any of the foregoing offenses. So this is interesting because they're probably going to say, well, he was trying to intimidate a witness here, so therefore this doesn't apply and he can listen in. But I still disagree, and I don't think that I don't think that he was doing it in good faith for law enforcement for catching a crime. He just has ongoing audio on his storefront like 24/7, so he can catch people in acts doing these things that aren't even witness intimidation. Like the thing that Turtle Boy did was harmless, yet they're trying to make another felony charge out of it. It's ridiculous. The term investigative or law enforcement officer means any officer in the United States. Okay, well, we know that. The term judge, okay, we don't need all those terms. Let's get to interception. Oral communications prohibited. Except as otherwise specifically prohibited in the section above, any person who willfully commits an interception, attempts to commit an interception, or procures any other person to commit an interception or to attempt to commit an interception of any wire or oral communication shall be fined not more than $10,000. Oh, Chris, Chris, you owe 10 grand and you could be imprisoned in the state prison for, well, he's not going to because he's a McAlbert, but he could be imprisoned in the state prison for not more than 5 years or imprisoned in a jail or house of correction for not more than 2.5 years, or both, so fined and given one such imprisonment. Proof of the installation of any intercepting device by any person under circumstances evincing an intent to commit an interception which is not authorized or permitted by this section shall be prima facie evidence of a violation of this subparagraph. So just the simple fact that you've installed these cameras that receive audio, you've violated this subparagraph. So you've already violated the statute. Editing of tape recordings in judicial proceedings prohibited. That doesn't apply here. Disclosure or use of wire or oral communications prohibited. That doesn't really apply either. Yeah, so a possession of interception devices. You're not even supposed to have the interception devices, even if they're not installed, I bet. Any person who permits or on behalf of any person who commits or attempts to commit, any person who participates in a conspiracy to commit. That's really complicated language, but basically, so if let's say it is a Canton public works camera that picks up audio. Maybe they have, they're working with Chris Albert and the Canton Police Department. I'm not saying, and I have no idea, and I'm not alleging this, but I'm just saying, like, for example, perhaps they're conspiring all, the Public Works, Police Department, and Chris Albert all conspiring to pick up these audio recordings of people so that they can use it against them and charge people with witness intimidation. Just saying. All right, so there, and it goes on and on and on and on. We're not going to read it all, but that gives us a good overview of what that statute is. Now, let's read the latest and greatest installment of Mark Bettero's letters. Letteros by Betteros. And I think this is the fourth letter that he's written, perhaps, but this is not to Robert Cosgrove, who is the the prosecutor in Carney's case, but this is to, as you can see, Helena Rafferty, the chief of police for the Canton Police Department. So she was not the chief of police when the crimes occurred, when John O'Keefe, when he lost his life. She was, I believe, the deputy. I'm not sure, but deputy chief. But Chief Berkowitz, Ken Berkowitz was the chief in question. He was actually on sick leave, I believe, at the time, or he was on leave at the time when it happened. So I believe Helena Rafferty might have had a lot more to do with the investigation of John O'Keefe than they've ever let on. Because if Kenny Berkowitz was out on leave, she would have been, second in command, I believe. And then once he retired, then she became the chief of police. This is a letter from Mark Betterow to Helena Rafferty regarding referral for criminal investigation of illegal interception of oral communications under the Massachusetts General Law 27299, which we just read through. So, dear Chief Rafferty, Along with co-counsel Timothy Bradle, I represent Aidan Carney, who is scheduled to appear in the Stoughton District Court on March 18th, 2025, which is coming up soon. In connection with his alleged witness intimidation of Canton Town Selectman Christopher Albert on March 4th, 2025, outside of D&E Pizzeria, which is owned by Mr. Albert. That matter is being investigated by Brian Tully. If you recall, Detective Brian Tully is the one who is persecuting Aidan Carney. He arrested him. He um, worked with outside individuals to try to, not to try, but to put him in prison for 60 days. So Brian Tully should not be on this case anymore, but he is. And he's adding this one charge. And he's from the Massachusetts State Police, if I didn't say that. All right. I write to formally request that the Canton Police Department commence a criminal investigation into Mr. Albert for apparent violations of this statute, interceptions of wire and oral communications, both generally and regarding the interception of Mr. Carney's oral communications outside of D&E on March 4th, 2025. As detailed below, there is conclusive proof that Mr. Albert A. repeatedly intercepts oral communications of people outside D&E without their actual knowledge, and B, unlawfully possesses an intercepting device with the intent to commit unlawful interceptions, which we just read, it's just having them is illegal. To the extent that the CPD is incapable of conducting a fair and unbiased investigation due to A. Mr. Albert's position as a town selectman, which grants him oversight over the CPD and your term of employment and compensation, he, Mr. Albert, Mr. Christopher Albert, is in charge of Helena Rafferty's contract of whether she's going to be reemployed or not. So this is a big conflict of interest. She should not be doing this, obviously. So he's asking, to the extent that the CPD is incapable of conducting a fair, unbiased investigation due to his position and the aggrieved party bringing this issue to your attention, Mr. Carney, who has been a very vocal critic of the Karen Reed prosecution and has criticized the CPD, MSP, and Mr. Albert, among others. So, of course, you guys might have some, hard feelings about the fact that Carney talks crap about you guys. I mean, not that it's crap. I mean, it's true, but he airs your crap, we should say. Also, Mr. Albert's brother Kevin Albert serves as a CPD detective and or CPD's vigorous yet unsuccessful attempt to prosecute at least 10 other individuals for allegedly intimidating Mr. Albert by exercising their First Amendment right to criticize the prosecution of the Karen Reed trial. I request that you promptly notify me whether you intend to refer this matter to another law enforcement agency. So if you aren't going to do this, we're requesting you do this, and if you can't do it because we don't believe you can, we want to know what agency you refer this to. And we have a footnote here. It says, as you are aware, acting upon Mr. Albert's claims of emotional and economic harm, the CPD dedicated staggering resources. More resources, in fact, went into researching, or not researching, but trying to prosecute the Canton Nine and the Rich Schaefer who had he had left the duck that said Colin did it near in the vicinity of Chris Albert. He could sense it. He could sense little rubber duckies. He can sense free Karen Reed people from afar, and it hurts his feelings. So the CPD spent a staggering amount of resources to prosecute the so-called Canton Nine for expressing their dissatisfaction with the Reed prosecution by protesting across the street from D&E, and Richard Schiffer, who left several rubber ducks around various locations in Canton, which criticized the Reed prosecution. charges were declined or dismissed against all these individuals after courts concluded that those targeted for prosecution by the CPD, meaning Canton 9 and Schiffer and all the others, were they were just exercising their First Amendment rights. Additionally, as he did in the instant matter involving Mr. Carney, on at least one other occasion, Mr. Albert contacted the MSP claiming that he was intimidated by a mother and daughter placing rubber ducks near D&E. Not surprisingly, those matters also were dismissed on the First Amendment grounds. Can you believe this guy? He tried to get a mother and daughter charged for placing rubber ducks near his place of business. Get out of here, buddy. Like his place of business is downtown. So a lot of people go downtown Canton frequently. So it's not like they're just picking and choosing his particular area necessarily or to intimidate him, just so that it happens to be a high traffic area. All right, so Mark Betterow lays out the relevant facts. D&E is located on Washington Street in the heart of downtown Canton. As the town's main downtown thoroughfare, blah, 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 I can't speak now. As the town's main downtown thoroughfare, Washington Street contains the heaviest pedestrian and vehicular traffic in Canton. So, like I said, it's just a heavily trafficked area. D&E utilizes two Wise cameras. So they have two recording devices, one of which is perched outside, aimed directly at Washington Street and the sidewalk. There are no signs or notices posted at D&E warning customers or passersby that their private oral conversations are subject to being intercepted and recorded. As reflected in Detective Tully's March 5th, 2025 report, outlining Mr. Carney's alleged witness intimidation on March 4th, 2025, Mr. Albert alleges that D&E's exterior camera intercepts and records audio from anyone within its range. We have a footnote that says on March 5th, 2025, Mr. Albert spoke to Detective Tully at 8:15 a.m. Detective Tully completed a 6-page report and sought Mr. Carney's custodial arrest for witness intimidation within 49 minutes of learning about the incident. Wow. If that doesn't show you that they were just waiting for Chris Albert to be calling them to say, hey, finally, I got Aiden on camera doing something, which isn't even illegal, but go get him. Ridiculous. I mean, this is someone's freedom that they want to take away. Again, like he's already done 60 days. Crazy. The camera located on the exterior of the building is audio recorded. Audio is captured by an exterior camera. In other words, Mr. Albert admits that he can and does intercept and record private oral communications. So those are his words. The camera located on the building is audio recorded. Those are Chris Albert's own words. So he basically got cell phoned. He did this to himself. He tried to get Aiden Carney on witness intimidation, and now he could possibly have some felony wiretapping. I mean, will it happen? Will Norfolk County go forward with the charges? I doubt it, but now it's on record at least to say, look at the discrepancy of how you treat people who are pro police, pro prosecution, whatever, and the people who question it, who don't take the narrative of the state and just go with it. So it's just, there's a huge discrepancy in the way that they're being treated. He says, in other words, Mr. Albert admits that he can and does intercept and record private oral communications by anyone in D&E's proximity, irrespective of their ignorance to the fact that they are being eavesdropped or recorded. Mr. Albert alleges that on March 4th, 2025, at approximately 10:20 p.m., he listened from the safety of his home to surreptitiously recorded video of Mr. Carney addressing Mr. Albert and his son Colin about the Reed testimony. That's actually, he wasn't really talking about the testimony itself. He was actually talking about, like I said, Peter Berger, not even the Reed case. Mr. Albert alleges that he was very upset about Mr. Carney's statements. Although not relevant to the issue of whether Mr. Albert is in violation of the statute for wiretapping, the video depicts Mr. Carney facing an interior camera rather than the audio-enabled exterior camera, which is located at the far end of the property. The wiretapping statute, requires the consent of all parties for the recording of oral communications. The statute's preamble details the legislature's concern with the uncontrolled development and unrestricted use of modern electronic surveillance devices, which pose grave dangers to the privacy of all citizens of the Commonwealth. Accordingly, a stated legislative intent on the statute is to ensure that the secret use of such devices by private individuals must be prohibited. So there you have it. They broke the law by recording people on the street. People like Turtle Boy, which they used that video that they recorded him, the audio that is illegal, legally obtained. They used that video to get Turtle Boy another charge and total backfire in Chris Albert's face. Unlike the Fourth Amendment, the wiretapping statute provides protection to an aggrieved person, a non-consenting recorded party, even where that individual does not have a reasonable expectation of privacy. So just because he's on the sidewalk doesn't mean he should have an expectation of privacy. It still is illegal. He has not consented to being recorded. Consequently, a recording made on a public sidewalk or thoroughfare may violate the statute. Secret recordings made on cell phone in public places, including sidewalks, were held illegal. Under but secret recordings. But if you're holding your phone up and people know that you're recording, then it's not secret. Under the Massachusetts statute, a recording is made secretly and thus illegally where it is made without the actual knowledge of the person being recorded. This means that Mr. Albert has no, I'm going to repeat that, Mr. Albert has no absolute right to record oral communications made by someone positioned on a public sidewalk or street within D&E's audio camera. Yet this is precisely what D&E's exterior camera is set up to do, to find Karen Reed supporters. Mr. Albert's blanket audio recording of individuals outside of D&E without their actual knowledge constitutes a felony under the statute, which states that any person who willfully and secretly audio records another without prior authority by all the parties to the communication is guilty of felony. Significantly, the statute contains an evidentiary presumption that proof of the installation of any intercepting device by any person under these circumstances, evincing an intent to commit an interception which is not authorized or permitted by this section, shall be prima facie evidence of a violation of this subparagraph. So basically, because just because he has the audio recordings, or because he has the audio recording devices in his possession and set up recording this, he is in violation of the paragraph, whatever subparagraph, meaning he's committed a felony. Put simply, Mr. Albert's installation of a recording camera, while aware that it would record audio without the actual knowledge of the intercepted parties, conclusively establishes that he is in violation of the statute. Additionally, separate and apart from the March 4th, 2025 incident, Mr. Albert's mere possession of the camera with the intent to audio record another without his or her agreement constitutes a misdemeanor under MGL, the wiretapping statute. other factors warranting an investigation. It is essential that the CPD be even handed in determining whether to investigate potential criminal violations without regard to any relevant party's views on a controversial matter of public concern, such as the merits of the Reed prosecution. So, regardless of what anybody's position is on the Reed prosecution, the Canton Police Department should be even handed in the way that they hand out their punishments or hand out charges, convictions, whatever, or not charges. The way that they hand out charges, they should be doing it for both sides, not just one. So here there is overwhelming evidence that a town selectman and longtime business owner is violating the law and flagrantly invading the privacy interests of anyone who makes oral communications within range of D&E's exterior camera. Failure to investigate here, which he's saying, like he's reminding you that you have a duty now to investigate. We just bringing this up to you is fine, but you also now have a duty to investigate. And if you don't, I can't do an asterisk. And if you don't investigate here, it will lessen the public's confidence in the CPD's ability to apply the law in an unbiased manner and to protect the public without regard to a possible offender's prominent political status in the community. His family's close relationship with the CPD and his involvement in and enthusiastic support of the prosecution of Karen Reed. Moreover, Mr. Albert's prior dissemination of recordings from D&E cameras to mock supporters of Karen Reed at the time that he has repeatedly at the same time, he has repeatedly and unsuccessfully accused several of them of intimidating him, and that's troubling and supports the need for an investigation. On September 26, 2024, Mr. Albert arranged for the public release of a video from one of D&E's cameras to humiliate an individual who had the temerity to peacefully exercise her First Amendment rights by writing FKR, standing for Free Karen Reed, on her vehicle window while it was parked in front of D&E. Mr. Albert recorded himself watching the video. He referred to the woman as a loser and a disgusting bitch, and then instructed someone to take her picture. Within a few hours, this video was provided to Catherine Peter, who promptly posted it on X. It stands to reason that if a town selectman is undeterred from making such inappropriate comments about his constituents or town visitors, and he is brazen enough to publicly disseminate the video to shame someone exercising her right to free speech, he is more than willing to secretly intercept and record oral communications made by others outside of his place of business. For these reasons, we request that the CPD investigate whether Mr. Albert's interception of oral communication of Mr. Carney on March 4th, 2025, or of anyone else within range of the cameras located at D&E violates the wiretapping statute. And that is signed by Mark Betterow and Tim Bradle, co-counsel, and Aidan Carney. We're copied on that. And that is beautiful writing. Mr. Betterow has a way with words. So, what do you guys think? Do you think they will investigate Chris Albert for wiretapping? I seriously doubt it. I hope they do, and I hope this kind of like forces their hand a little bit, this letter, because it puts public pressure on them. And if this doesn't, I'm sure if that doesn't work, they could go to the FBI and they could go to the AG's office. They could do something else. They could send another letter similar to this and title it, Massachusetts Attorney General. We've got a problem in Canton, and a town selectman who is so brazenly and willingly able to violate the law repeatedly over and over again and weaponize the laws and the statutes um, to retaliate against people that criticize him, basically. So he's a piece of garbage. People, witnesses in this case, I have no tolerance anymore, and I'm just gonna say it like it is. Chris Albert is a piece of garbage, and so is his son, and I think they're both involved. And I also think that D&E might be some kind of a storefront for some other kind of organized business, which is also why I think it was interesting that that statute talks about organized crime because I have thought for quite some time, there's never anybody at D&E's Pizza. There's hardly any customers. So how are they staying in business? And how is Chris paying off his debt and things just like all of a sudden? It's just bizarre. And I don't know. I'm speculating just from what I've seen that maybe it might be a front or something else, but I don't know. And I can't verify that, but it seems that way to me. What do you guys think? Do you think that D&E is a front for some kind of organized crime, some kind of Albert mafia going on in the background? Or do you think that Chris Albert is totally on the up and up and he never would lie and he totally didn't mean to record Turtle Boy? Do you think that? Because I don't. Let me know what you guys think in the comments below, and I will see you guys in the next one. Be sure, please, to hit the like button on your way out and to be subscribed for upcoming videos. We have lots and lots of document drops coming soon. So I will update you guys as we get them. And take care. Bye now.